Do you have a stepchild, or are you the stepchild? Are you in a blended marriage? I know, discussing inheritance in a blended marriage can be a sensitive conversation. Believe me, I know. However, the conversation should be had at some point during the marriage, preferably twice, once between spouses and again with their attorney. I've seen too many cases where things get contentious even with estate planning. However, things often get downright nasty when there hasn't been any planning at all. In today's video, we're going to talk about stepchildren and when they can be considered a natural heir of a deceased person and thus a beneficiary of the estate, even when there's no biological connection between them. And no, I'm not talking about cases of adoption either. Be sure to hit the like button, subscribe, and ring the bell. Share the video with someone you know in a blended marriage, and let's get litigating. The case we're examining today is a recent one, published October of 2023, and involves two Nicks, Nick Martino and Nick Zambito. The case is the estate of Nick Martino, who died intestate, meaning without a will. The central question centered around whether Nick Zambito, Martino's stepson from a previous marriage, and whether Martino could be considered Zambito's natural parent for the process of intestate succession, despite there being no biological connection between them. And of course, no adoption occurred at any point in time here. Martino's biological children, Tracy Martino and Joseph Martino, objected to Zambito's claim. However, the probate court determined that Zambito was indeed Martino's natural parent under probate code sections 6540 and 6453. This decision was later affirmed by the Court of Appeals, highlighting a significant aspect of California law where familial relationships can define legal heirship, not just biological connections. I want to stress that point. The nature of the relationship between the parties trumped or overcame the biological reality of no blood relationship between the parties. To put it into more casual language, we have a feels over reals outcome here. Nope, I'm not talking about you two. Go away. We're not talking politics here. This case illuminates several key principles, particularly around the definitions provided in the probate code for determining natural parentage and the role of the Uniform Parentage Act, the UPA. Specifically, probate code section 6453 and family code section 7611 subdivision D played pivotal roles. Probate code section 6453 tells us to look at the family code to determine whether a person is a natural parent in cases of inheritance and succession, while family code section 7611D creates a presumption of natural parentage if a parent receives the child into their home and openly holds them out as their natural child, a criterion that Zambito met based on the court's findings. This case reinforces the notion that natural parent status, crucial for intestate succession, can extend beyond biological ties, embracing those with substantial familial relationships. Again, no adoption here. If you adopt someone, then they are legally considered on equal footing as if they were your direct blood relative. Furthermore, the appellate court addressed and rejected an argument concerning judicial estoppel, which the Martino children presented, claiming Zambito had previously identified someone else as his natural father in a different legal context, thus he couldn't claim that right here. Essentially, they argued that Zambito claimed someone else as his natural parent previously. Coincidentally, another probate case in another state. The court rejected that argument, saying that it had no bearing on Zambito's claim here, since one can have more than one natural parent, and primarily, that other claim had no bearing on the nature of this claim and the facts giving rise to it. This aspect underscores the complexities involved in legal interpretations of family relationships and the importance of consistency in legal claims. For full context of the case, Zambito lived with Martino for 8 years, 6 of which Zambito's mother was married to Martino. Zambito carried on a close relationship with Martino even after the divorce, maintained little contact with his biological father, and considered Martino to be his true father. Zambito served in the military for 20 years, during which time he maintained contact with Martino. After retiring from the military, Zambito visited Martino and increased the frequency of these visits when Martino's health began to decline, going so far as to accompany Martino to medical appointments. Martino's friends testified that Martino always referred to Zambito as his son, that they also referred to Zambito as Martino's son, and that this close relationship was maintained even in Martino's final years. I won't speculate as to where Martino's other 2 children were, but I will point out that neither side disputed these factual findings or raised a sufficiency of evidence issue, as in, they never contested these facts. So what can we learn from the Martino estate case? First and foremost, specificity in estate planning documents cannot be overstated. While Martino did not leave a will, those undertaking estate planning should clearly define relationships and intentions within their documents to avoid similar disputes. Moreover, being truthful and forthcoming with your estate planning attorney about all familial relationships is crucial. As this case demonstrates, the legal system's interpretation of family ties can have unexpected outcomes on intestate succession, potentially diverging from what may have been presumed intentions. There's no reason to hide information from your attorney. We have a legal obligation to keep your confidence, and the only way we can do that and give you the best advice is if you give us the facts so we can sort through them all and give you an informed opinion. The estate of Nick Martino case is a testament to the evolving nature of family dynamics and their impact on estate law. As we navigate these complex waters, it's imperative to consult with a knowledgeable estate planning attorney to ensure your estate plan accurately reflects your wishes and accounts for all potential heirs. But let me pass the question off to you. What do you think about the Martino case? Do you think a judge should be able to determine whether the nature of your relationship with a non-blood relative entitles them to a piece of your estate? Let me know in the comments below. Remember to like, subscribe, and share this video with someone you know in a blended marriage or your favorite stepchild. I'm attorney Andrew Bethel, and I'm here to help make sense of the laws that impact your life and estate, and I'll see you at our next meeting.